A decision today by the nation's highest court that could have major implications for the unprecedented and historic criminal prosecution of Donald Trump. The justices announcing today that they will hear an appeal by a January 6th defendant. His name is Joseph Fisher. He has been indicted on 7 charges related to the insurrection, including obstruction of an official proceeding, which is also, as you know, a charge brought by special counsel Jack Smith against Donald Trump. Now, Fisher is seeking to dismiss that count. The central question before the Supreme Court, according to the New York Times, quote, can the government charge defendants in those cases under a federal law that makes it a crime to corruptly obstruct an official congressional proceeding? And here's how the Times lays out the stakes of this move by the Supreme Court today. Quote, the decision to hear the case will complicate and perhaps delay the start of Mr. Trump's trial, now scheduled to take place in Washington in March. The Supreme Court's ultimate ruling, which may not arrive until June, will likely address the viability of 2 of the main counts against Mr. Trump and could severely limit efforts by the special counsel Jack Smith to hold the former president accountable for the violence that his supporters committed at the Capitol. Whatever the justices decide could also have a major impact on what has become the largest investigation in DOJ history. Prosecutors have also charged more than 300 defendants with obstruction of an official proceeding. Some of them have already been convicted. The Supreme Court's decision today, just one of many factors that could upend the case. There's also the matter of Trump's appeal of Judge Chutkan's ruling that Trump is not immune from prosecution because he was president at the time that the alleged crimes occurred. We have some breaking news on that front. Just moments ago, Judge Chutkan ordered a stay of all proceedings in the federal election case until Trump's appeal is settled. And it is a lot, is where we start today with former lead investigator for the January 6th Select Committee, Tim Heaphy. And with me at the table, NBC News justice reporter and author of Sedition Hunters, How January 6th Broke the Justice System, Ryan Riley, and MSNBC legal analyst Lisa Rubin. Could not think of better people to be with us today. Lisa, break down this ruling from Judge Chutkan. What does it mean?
The ruling from Judge Chutkan, Alicia, essentially confirms what Jack Smith's team told her over the weekend. The trial cannot go forward until Trump's assertion of constitutional immunity is resolved, either by the D.C. Circuit or by the Supreme Court. At the same time, she is giving Jack Smith's team what they said they wanted. They are saying to her, you still have jurisdiction to enforce the basic rules of this proceeding. That means you can hold Donald Trump and his lawyers to the gag order. You can enforce his conditions of release, which are the circumstances under which he is still a free man, having been indicted. And maybe even most importantly, you can enforce the protective order that governs discovery in this case. You'll remember Trump has been given 13 million some pages of discovery in this case. And a protective order precludes him from sharing that with the general public, a la Regina George in Mean Girls. He can't walk into the proverbial public hallway, make photocopies, and toss them into the air and see what happens. He still needs to keep those materials secret until further order by the court. So this is essentially what Jack Smith's office told her should happen, but now it cements it. It makes it official and means that the next step has to be taken by the Supreme Court, or if they decline to take up the case, by the D.C. Circuit.
So, Tim, given all of that excellent context, what do you think? Did a March 4th trial date just become less likely?
Yes, less likely, but not off the table yet, right? There's a scenario by which the Supreme Court could immediately decide that the significance of resolution of this immunity issue justifies immediate relief. They order expedited briefing and it's resolved early in the year and we maintain the March 4th trial date. They could also say, no, we're not going to take the case, in which case the D.C. Circuit has to go first. They also could do it on an expedited basis, and then the Supreme Court could decide not to take it, or it could go forward on March 4th, even after a D.C. Circuit ruling, if the Supreme Court is still considering it. So it's not off the table that March 4th holds. Judge Chutkan notably didn't vacate the trial date or any other deadline. She essentially held them in abeyance as this appeal of the immunity issue moves forward. So I'd say it's less likely than it was before this order, but it is not yet a sure thing that it'll have to be extended.
Well, Tim, I want to add on to this, the news out of the Supreme Court about Joseph Fisher. Again, if you're Donald Trump's lawyer, if your strategy is to do anything you can to delay a trial, do you then sense an opportunity right now?
Yeah, look, absolutely. But it's important to realize that Donald Trump is in a very different position vis-a-vis the official proceeding than Mr. Fisher, the appellant in that case. He is claiming that there needs to be some nexus to documents. 1512C2 follows C1, which talks about altering, mutilating, destroying a document. And his argument essentially is that you have to read C2 in connection with the document issue. And it was a Sarbanes-Oxley law that was designed to protect documents. Donald Trump does have involvement with documents, right? The submission of these fake elector certificates. So even under the Fisher appellant's theory of 1512 that's before the Supreme Court, arguably that could be applied to President Trump in a way that doesn't apply to the sort of blue-collar rioters at the Capitol. So it affects him. Obviously, Supreme Court interpretation of 1512 has a bearing. But even if Fisher wins and the government loses in the Supreme Court, that doesn't mean that the 1512 counts go away against President Trump. And he's also charged with 2 counts beyond 1512, which would be unaffected by that appeal.
I want to come back to you on this question of obstruction and how it affects different people differently, but your sense of how all of this impacts the federal election case?
Yeah, I mean, I thought that the March trial, Judge Chutkan really seemed to be trying to get everything on schedule for that to actually take place. And that March 4th date, I do think comes a little bit up in the air with all of these new legal developments. But, they're going to continue down the avenue on this. The impact that I'm most interested in also, in addition to the Trump cases, this is going to impact over 300 of these other
talk
cases.
To me about that.
So, I mean, a lot of these cases have worked through the proceeding. A lot of people are being held. Some people who are being held pretrial, that's one of the charges that they're facing. So it really has had this enormous impact, and you're going to have to go back potentially and look at each of these cases individually and figure out whether or not some time gets shaved off of some.
So why did this not come up sooner?
It had to work its way through the system, right? So this all started because a Judge Carl Nichols decided that this shouldn't apply to this sort of activity. And the cases that he was handling, he's the only judge who did this in the D.C. court. He said that this charge cannot go forward, right? So it had to work its way up through the system. So in the case of 2 of these individuals who are sort of appealing this to the Supreme Court, they haven't gone on trial yet, but the other one actually has already been sentenced separately for everything except for that one charge. So these are individuals, a lot of them who actually physically stormed the Capitol. Joseph Fisher, the cop, for example, the former cop, is from Pennsylvania. He was involved in this push. There's, photos of him at the Trump rally, sort of hamming it up with all these sort of celebrities, I guess, in the MAGA world, and then storming the Capitol that day. The other individual, actually the one who has been sentenced, who was a part of this sort of appeal, actually was arrested while he was wearing a shirt that said, "I was there on January 6th." So, yeah, it's really a full spectrum that you're getting of the January 6th defendants here.
Lucy, can I add something here?
Please.
Because, one of the things about this statute, and I hadn't focused on Fisher's cert petition until today, one of the things people have been focused on about this statute is the meaning of the word corruptly. But that's not what Fisher's appeal is about, as Tim just explained. His appeal is about whether or not it's lawful to charge him with otherwise obstructing or impeding the congressional proceeding on January 6th because it's not tethered to documents. And here's where it's sort of, pardon the expression, kind of stinks to be a textualist, right? We've seen from the conservative movement that what should matter when we're looking at the meaning of a statute is the plain meaning of the statute. But here, the plain meaning is pretty clear. Aside from this mutilating or concealing a record, they are prohibiting otherwise obstructing a proceeding. What did these people do? They blocked doors. They prevented members of Congress in both chambers from safely voting on January 6th. I can't think of any clearer meaning of obstructing a proceeding than the one that applies to these cases. Whether that applies to Donald Trump might be a little bit different, but at least it should apply to the conspiracy count to obstruct a proceeding on the face of the indictment.
Well, Tim, let's talk about that point, because I do appreciate, as a person who decided not to go to law school, that sometimes referencing all these statutes can sound a little technocratic. But the 1-6 Select Committee recommended that Trump be charged with obstruction of an official proceeding for a reason. Tell us why.
Yeah, so we were relying upon the D.C. Circuit opinion, which is now being appealed, that was consistent with every other judge, trial judge, other than Judge Nichols, that, as Lisa just said, you can't obstruct an official proceeding by otherwise, beyond documents, impeding, interfering with, or taking steps that are going to make that proceeding less likely to occur. The plain language, as Lisa just pointed out, is otherwise applies to this whole other category of conduct beyond the mutilation of a document. And that has been the consistent interpretation of every other federal judge. That's what the D.C. Circuit has ruled. Then the Supreme Court will evaluate that. Our recommendation was specifically that 1512C2, this otherwise provision, applies to blocking doors and broadly the submission of the fake electors, the attempt to pervert and use the processes of the Department of Justice and the congressional proceedings, state officials, all of the multi-part plan constituted a conspiracy to, including documents, obstruct an official proceeding. So again, either way the court goes, Jack Smith has an argument that President Trump has violated 1512C2. All the other defendants who weren't involved in documents have a much stronger argument if the court goes the way of Mr. Fisher that those 1512C2 counts cannot stand.